potentially on one of our cases where Mr. Lawrence is the guardian ad litem. So let me see, do I have Stephen Utter with us and Kirby Llewellyn?
Yes, I'm here.
Or Kirby Young?
Yep.
Do we have Mr. Utter with us? Ms. Young, are you expecting Mr. Utter today? I do see you all presented an agreed order.
I know he worked nights last night, so I'm assuming he probably overslept, but I'm not sure. But we got the papers turned in and he was going to get a copy to Mr. Lawrence.
Okay, let me just check. I think I'm probably going to wait a few minutes for him, but this is on 233-000-4808. Mr. Lawrence, were you, I know last time we were together, we were hoping that the parties would give you a copy of their proposed parenting plan. Have you received that?
Not yet, Your Honor. I received an email yesterday from Kirby indicating that Steve was supposed to provide me with a copy, but I haven't seen it yet.
Okay. So let me just double check. Do I have Mr. Utter on? Okay. I think what I'd like to do, because you all are proceeding without an attorney, I know when we were together last, my hope was that Mr. Lawrence would look at this parenting plan to give any feedback if there were small points of disagreement or things that the court just can't do. My proposal would be, and hopefully Mr. Utter could be in attendance, would be to just set this over 1 week to next Wednesday, August 23rd. Ms. Young, would you be available?
Yeah.
Okay. And Mr. Lawrence, would you be available?
Yes.
Okay. And then I'll just ask one more time, do we have Stephen Utter online with us? Okay. So Ms. Young, if you're in communication, with Mr. Utter, just let him know. We'll set this to next Wednesday at 9 a.m. And then if the court does have a copy of the joint agreement the two of you signed, looks like one of you on August 12th and one on August 14th. So if you can get that to Mr. Lawrence, today or tomorrow, that would be really helpful.
Yep, I will do that.
Okay. Anything else on this matter, Mr. Lawrence or Ms. Young? 208. I don't think we are here for, by my notes, is review on compliance. I did issue and sign last time we were together on July 19th an order on contempt, excuse me. I did also state at that hearing that I wanted to have some payments be reinitiated before today's review date. So first, Mr. Hansen, let me ask you what progress you've been able to make.
I made a payment right after our first court, and I'm able to make a payment today.
Okay.
I still haven't our last meeting.
Okay. And then how much did you make after the first court date? What was the payment amount?
$1,250.
Okay. And then what's the amount you're expecting to pay today or shortly around today? Same.
$1,250.
Okay. Okay. Ms. Hansen, let me turn it over to you. I had already signed the contempt order for the past due support of $5,000. What are you asking of the court today, or would you like to simply set a new review date to make sure these payments continue?
I'm happy with getting the payments started back up. I would like the past 5 months caught up, and not have to wait till the end of the year.
Yeah, I think that we talked about that last time, is because what is the monthly obligation, the current, not the past due, but the current monthly each month?
$1,250.
Okay. So, sir, what it sounds like to me is that you're back in compliance on your monthly payments, which is good. I understand money can be tight, but the contempt order I signed in July was for $5,000 of back payments. And we need to see some progress on payments above and beyond just keeping current. We need to see payments on that contempt order, which right now is standing at $5,000. So what can you tell me about your ability to make payment on the $5,000?
Well, we're still working without a contract, and we're supposed to vote on that on the 23rd. There's a lot of employers that are afraid to start work up in case there's a lockout. And so if in fact we agree to the contract on the 23rd, there will be a retro check that I will be able to catch up on all the past due.
And that's next August 23rd, next week?
Yeah, but I don't know how long it'll take to get the check.
Right, understood. This would be my proposal. Please stay current on your monthly amounts.
Okay.
I want to set this out 2 weeks to August 30th, which will be just after that vote occurs, so that we can touch base about how likely it is we're going to see payment on that back support come in.
Okay.
Okay, Ms. Hanson, what I'll tell you is if we're together on August 30th, that'll be at 9 a.m. again, same link, and we're not seeing progress or at least a promise to pay, the court will consider additional sanctions on the contempt motion.
Okay, thank you.
Okay, so Mr. Hanson, do the best you can. Thank you for being here today. Thank you for staying current on your monthly support. And we'll see you back on August 30th at 9 a.m. This is John Gilbert, all right, and Aaron Gilbert. Do I have both of you present?
Yes.
Yes.
Okay, great. That's you and iPad 1. Thank you. And I do have Mr. Lawrence on here. Give me a second just to pull up your digital file. So when we were together last on August 9th, I think one of the concerns the court raised was we have this adequate cause motion that's been hanging out there. There's been ruling reserved on it, but in the meantime, a judicial officer had changed, at least temporarily, visitation pending some additional information coming in. I've reviewed the evaluations or not evaluations, but the UA reports that have come in. I think that was one of the things the prior commissioner was wanting. I've looked at the documents from the original show cause motion. I haven't, Ms. Gilbert, received any additional information. I think when we were together last, you were maybe going to supply some additional information to support your request for adequate cause finding.
Yes.
I haven't seen that. So first, I'm going to turn it over to you, then Mr. Gilbert, and then I'm going to get input from Mr. Lawrence. So
Okay.
Go ahead, ma'am. Where are you at with evidence and your request to change the parenting plan?
I did file paperwork on Friday. So I received, a notification that John's wife had her daughter, taken away or lost custody. And so I got that information and filed it with a declaration on Friday, just with some other stuff, a text from John saying that he agreed that his house is not a good place for Max. And a declaration from his stepson about John's behavior.
Okay, so I'll tell you, unless you provided a bench copy, which is a second copy for the clerk to give to me, there's absolutely no way I would receive your documents if you dropped them off Friday. So they're not in our digital system either. We have nothing scanned in since August.
I don't know what that means. I have to request specially for it to go to you?
No, it just means you can't drop things off 3 days before a hearing. It's not going to get scanned in administratively, and it's not going to make its way to me unless you deliver a second paper copy that's called a bench copy. So I have nothing that you're discussing in front of me.
I thought that it just had to be filed by Friday. I must have misunderstood. I mean, last time I filed it on Monday before court and you had it then, so I just must have misunderstood, but I did file something, so I'm not sure.
Okay. Let me chat with Mr. Gilbert. Mr. Gilbert, have you received the documents that she's referring to?
I got an email from her. Yeah.
Okay. What's your position on this? She's seeming to allude that you are in agreement that your house is not a suitable place for the child right now.
It is now. I'm the only one staying at the house.
Say that again. I didn't catch it.
I'm the only one staying in the house, so it's a safe spot for the kid.
Okay. You're talking about, so Brenda is out of the house?
He's not staying in the house right now. No.
Okay. Well, I don't have anything in front of me.
I did give it to Keith, the guardian.
Okay. I'm going to talk to Mr. Lawrence shortly. Anything else, Mr. Gilbert, you want me to know? Are you objecting to a change in the parenting plan at this point?
Yes, I object to it. I want it to stay exactly the same.
And as I see, you haven't had visitation now for quite some time because of these temporary orders. Is that right?
A very long time.
Okay. And I did receive your negative and review your negative UA results. So let me turn it over to Mr. Lawrence and get some input. It sounds like, Mr. Lawrence, you may be privy to documents I haven't seen, so I'll ask for a little input from you.
Yes, Your Honor, I did receive an email from Aaron last week. And as she indicated, there was several documents in there. There was a statement by Brenda's current husband, or past husband rather. There was a statement from Aaron and John's older son. And from what I gleaned out of the number of documents that she sent, is that there's complete chaos going on between Brenda and John in their home. And I would not recommend that the court allow visitation if the two of them are residing in the same home. John has undergone his drug and alcohol evaluation, but if the two were together, I would recommend that the court consider John undergoing a psychological evaluation with a parental risk component. If those two can't separate somehow, this is no environment for Max.
Mr. Gilbert, do you want to respond to that?
Yes, like I said, we're not living together. I was a father before I was a husband. I'm a dad. And I lost my parenting rights over a bunch of stuff that I proved. I don't do drugs. I don't do any of that stuff. So yes, we are not living together.
I'm looking to see, and I don't have confirmation of that, sir. I can certainly take your word here right now, but I don't have a declaration to that effect from any individual. I'm looking to see if we have an order on the adequate cause. Ms. Gilbert, have you filed a proposed order on the adequate cause decision?
The proposed parenting plan?
No, it's called an order on adequate cause.
Oh, I do not believe so.
Okay.
I do have something to say about him and Brenda being together if I have the opportunity sometime.
Go ahead.
Oh, just that he has, I mean, this has happened multiple times where he says that him and Brenda are no longer together. And then they are together, unfortunately. And I do believe that this is just a lie, unfortunately, to get Max back. Anyways, yeah, I just do not believe that even if Brenda is not living there, which I do not believe that she's not, but if she isn't, I believe that would just be temporary. They very much have a history of breaking up and getting back together. So until things are final, I would not like Max to go there.
So here's what I'm going to do. I think this motion for adequate cause has been hanging out there way too long, and the court needs to make a ruling. Based on all of the evidence in the file, including input from Mr. Lawrence, I do believe the first ruling I'm making today is that there is adequate cause to change a parenting plan. This doesn't mean that I'm adopting any specific parenting plan right now. What it means is I believe there's enough evidence to move this forward to a trial, but maybe mediation first on what the new parenting plan should look like. So after today's docket, I'm going to fill out what's called an order on adequate cause to change a parenting plan. I will find that Ms. Gilbert, who was initially the respondent in the underlying action, did make a motion for adequate cause decision, that today we did hold the adequate cause hearing, that I have jurisdiction over this case, and that I am finding that there is adequate cause to hold a full hearing or trial on the petition. The trial date will be set at a later date when we have further, when we're ready to get to that point. The other findings I'm going to put in this order are that for now, the prior judicial officer's temporary orders suspending visitation remain. Mr. Lawrence, what were the evaluations you were recommending? I wrote down parental risk assessment or component.
Right. Yeah. A psychological evaluation with a parental risk component.
Okay. I am going to add that, Mr. Gilbert, to the order as an affirmative obligation that you will need to do. What I'm going to do after that is, and Mr. Lawrence, do you still have time with us on this case to remain as GAL?
I'm available to remain. However, my funds have run out.
I would like to keep you appointed to this now that I am finding adequate cause and moving this on to a hearing, trial, or mediation on changing the parenting plan. I will approve a request for additional time and money on this.
Okay.
Do you have a template order you could send over to me ex parte on that, or do you need the court to do it?
I don't have a template, Your Honor. I'm sorry.
Okay, let me just make a note for myself. And I'll get that done after docket as well when I do the adequate cause motion.
Your Honor, can I please at least just get the weekends with my kid?
Not right now, sir. I do want, what I'm going to do is set a review date. And we're going to set it 30 days out. And I would like you in that time as best you can, certainly understanding it is difficult to get into medical providers. I would like you to get the psychological assessment with the parental risk assessment. I am also hopeful that by me approving some additional time and hours from the GAL, that we can kind of get to the bottom of what your living arrangement with Brenda is. I'm not convinced standing here right now that more likely than not, the two of you are permanently not residing together. So I am going to need some further input on that. So my hope is when we come back in 30 days, it'll be both a review hearing on kind of the immediate visitation issue and your compliance with the psychological evaluation. But then I would also like to address at that hearing whether you're ready to go on to the full hearing or trial on permanently changing the parent plan or not. Okay.
Okay.
So that's going to be, I'm looking at September 13 or 20. Mr. Lawrence, do you have a preference?
Your Honor, the parental risk assessment can take several months. So,
Oh, okay.
so the 20th would be preferable. I can address the living situation and I can address whether or not Mr. Gilbert is attempting to set up an appointment, or he may even have an appointment, but it may be down the road.
Let's do that. I think that's a great idea. And thank you for that additional clarification. So let's set this to September 20th at 9 a.m. back on this docket for a review, for essentially a status review on those two issues. And then we will also talk about, I know Mr. Gilbert, you want to move this forward. We can talk about whether we're ready to get you guys sent on to, mediation or a trial. Okay.
Okay.
Any questions for me on this matter? Otherwise, I will get the adequate cause finding signed and filed. I'll get the additional time and money approved for the GAL, and then we'll see you back on September 20th.
Yeah. Since Keith brought it up, or what? So where's the best spot to get these evaluations?
Your Honor, the only person that I know of locally that does that is Dr. Stephen Maharg at Northwest Psychological in Longview.
Do you have any idea what that costs?
It runs around $1,500. The last I heard, I don't know what his current rates are, but I can provide John with Dr. Maharg's contact information and so he can get started.
Okay. Thank you. I appreciate that. All right. Ms. Gilbert, Mr. Gilbert, you are free to log off. When we were here last, and I did receive some new documents just yesterday. I'll talk about those in a minute. But when we were here last, Mr. Bondurant, you did claim that there was a court order from December 2022 that superseded or changed the 2021 parenting plan. And I asked you to file those documents. And I got new documents from you, but it appears that it's not actually any parenting plan. It's just now your request for contempt against Ms. Flick. And that's, hold on, sir. And your motion for contempt, you've set on for the docket in 2 weeks on August 30th. So I guess let me first just be very clear and ask you a very specific question. I want a very specific answer. Have you filed with the court what you claim is a December 2022 order that changed the 2021 parenting plan?
Yes.
You have filed that. When did you file that with the court?
We got the last of the paperwork emailed to us yesterday. It was filed around 11:30 a.m. yesterday. At the same time, the contempt paperwork was filed.
I'm going to go back through what I was handed from yesterday's filing. I don't see that here. Ms. Flick, have you been served? Hold on, sir. Ms. Flick, have you been served with that document?
I have not.
Okay. Let me just check with the court. Would there be a way for someone to check if there are any other papers he filed yesterday? We're just going to take a minute and double check because Mr. Bondurant, I'm just essentially wanting to confirm if what you're telling the court is true, because I was handed several pages of your filing from yesterday and it does not include anything that would even come close to being a new parenting plan.
There was about 80 pages that we filed.
Hold on, sir. Do you have access to that?
I don't, it is not scanned in.
Oh, because it's not scanned. Okay. And it states it's a declaration.
Like Isaac.
Okay. So, sir, tell me exactly what you filed yesterday, because our system is showing no one can see it because it hasn't been scanned in yet to my system and I don't have a hard copy, but it's claiming to be a declaration. So what is it that you filed with the court besides your motion for contempt? Can you explain to me what it says and what it is?
It was a motion. There was a hearing. There was a motion to vacate the original parenting plan, and it stated in there that that the non-custodial parent, which was me, had the children 50% of the time. And there was a declaration signed as well, but that was like part 3 of everything that we sent in yesterday. Yeah, that was just explaining the documentation that we did file.
Just not seeing anything here I've pulled up your dissolution case number where they would have addressed the parenting plan. There's just nothing else in there.
I spent like 2.5, 3 hours there because there was some on the contempt paperwork. There was some issues where they just had us keep updating it and fixing it. But so I can speak for what happened to those documents. They were filed yesterday at the same time as the contempt and the declaration. I mean, it was like 80 plus pages of documents.
Yeah, so you probably heard me tell someone who filed documents on Friday, filing them 24 hours or less before hearing is in no way going to guarantee or even, it is just not going to get to me. So I just want to be clear for everyone who's hearing this docket today. I know you all are unrepresented. I know that can make life difficult, but really the rules state you've got to file things 5 days before your hearing or the court doesn't have to consider it. Part of that reason is you've got to give the other side plenty of notice that documents are coming in and going to be relied upon. And again, we show up here, people say they have filed things and I have nothing in front of me. So, filing things a day before you come to court is not proper. I'm going to look at the original motion for contempt that Ms. Flick filed, which is what we're here on. Mr. Bondurant, you have filed your own contempt motion that's scheduled for August 30th. So we'll let that stand. But for Ms. Flick's motion, I know one of the questions I had at the last hearing beyond, hey, is there a new parenting plan, is where is the child? Ms. Flick, has the child been returned to you at any point since July 24th?
She has not.
Mr. Bondurant, what can you tell me about that? Because what you're telling the court is that there's a parenting plan out there that says 50-50, but if you're holding the child 100% of the time, you're still not complying with that order, even if it does exist. So what's up?
Okay, so we had gone on the 24th, I believe it was, to on my normal scheduled rotation for 50-50. We had went to her house, me and my wife. There was altercation, some issues. I was only able to grab Riley. I got her in the car, and she wouldn't give me Kinley. So that's kind of where we're at now.
Why are you,
I've also been,
hold on, sir. Why are you keeping the kid 100% of the time? If the argument you're making to the court is best case scenario, there's an order out there that says you get her 50% of the time. You are unlawfully withholding the child at this point. Do you see that?
yes, isn't she unlawfully holding Kinley? I haven't seen Kinley for over a month.
Sir, not here on your motion. You scheduled that for August 30th. Okay, you filed that for August 30th. Here's what I'm going to do. I am going to set both of your show causes motion, both of the show cause motions for contempt to August 30th, because I want to see what you did file yesterday before I rule on contempt. But what I am going to say, and what I am going to put in a bench order, and Ms. Flick, let me know, if this is doable for you, but I do want the child returned to Ms. Flick by 3 o'clock today. Ms. Flick, I don't know if we can work on that time. I don't know what your work schedule is. Let me know.
Yeah, that's perfect. I just want her back today. And I will say, I know it's for a different day, but the reason he doesn't have Kinley, and I have a recording of him saying it when he grabbed our oldest, he said, I got one kid and you got one kid and you won't see this one again.
Yeah.
So that is why he doesn't have Kinley.
And Mr. Bondurant, I also, in looking through your case history, see that you've got some other stuff going on where you've got restraining orders against you from July.
It was a conflict I had with a neighbor across the street that has no bearings on my children.
Okay, well, all right. So here's my ruling. I'm going to fill out a bench order today requiring Mr. Bondurant and make sure I put the right child's name in there. Ms. Flick, can you spell it for me?
It's RYLEI.
Riley, sir, must be returned to Ms. Flick by 3 p.m. today.
And ma'am, what about Bondurant? When am I going to see my other daughter?
That's not in front of me. You filed a motion for contempt on that issue, and you scheduled it for August 30th. I'll deal with it on August 30th.
So I don't get to see my kids up until that point?
Sir, that's when you asked the court to hear your motion.
We have done 50-50 for a year and a half. We've done 50-50.
Mr. Bondurant, what is before me today that you were on notice of since our last hearing was you withholding Riley from Ms. Flick. That is what is the only thing. Sir,
I have 5 days to get those documents.
I will mute
get an
you.
adequate 30.
Okay, here's something that people don't understand. We're on Zoom, but this is still a courtroom. I am speaking and issuing my ruling. I will ask for questions when I am done, sir. What I am telling you procedurally, the only issue in front of me is Riley's placement. You, sir, have asked me to address the other child, and you've asked this court to address it on August 30th, and that is when I'm going to address it. You didn't ask for it to be addressed sooner. You asked for it to be addressed on the 30th. My ruling today is that I'm going to set over the ruling on the contempt motion by Ms. Flick to August 30th so I can review what you filed yesterday. But in the meantime, because everything in front of me shows best case scenario, you have 50-50. Very best case scenario, you have 50-50 time, and you haven't given Riley back to Ms. Flick since July 24th or so. You are to return her by 3 p.m. today. If you do not, Ms. Flick, please note on our motion docket for next Wednesday, a new contempt motion, and we will address it on Wednesday.
Okay.
All right. Anything else on this matter? Mr. Bondurant, do you have questions for the court?
Not that you'd answer for me. I'm all right. Thank you.
All right. We'll see you both back on September 30th. I will be filing that order at the end of docket today.
You said September 30th, or did you mean August?
August. I'm sorry. August 30th.
I just wanted to make sure.
Yes. August. 2 weeks. Do we have Anna? All right.
Bailey?
Thank you.
Thank you.
Yes, I'm here.
Okay. And then I don't know, I do see kind of on the underlying matter, you all have had Rhonda Larson, I believe, as a GAL. Is Ms. Larson with us?
I believe she's retired, Your Honor.
Okay. We might need to update our records here. She hasn't been actively involved in your case for some time. Is that right?
That is correct. Our case ended in 2021.
Yeah. So I'll tell you all what I have in front of me. I know it gets a little complicated. So if I get this wrong, obviously please jump in. So I have Ms. Manley. It appears you have filed a motion for contempt / to show cause that is set on for next week, August 23rd. What I have on for today is Mr. Fike, you filed a show cause contempt motion to be heard today. And it looks like you filed that on July 27th. And then we also have on the docket a filing for adequate cause hearing to change the parenting plan. So that was filed, I think maybe you both have filed. Have you both filed to change the parenting plan or just Ms. Manley?
I was the one that filed to change the parenting plan custody order. I believe she and her declarations for contempt or her response was to keep it the same.
Okay, so Ms. Manley, you today, and tell me if I'm wrong here, you today are here to object to a finding of adequate cause to change the parenting plan, and then also to respond to Mr. Fike's contempt motion. Is that correct?
Yes.
And then you have also separately from today filed a contempt motion, and that's scheduled to be heard on August 23rd. Is that also your understanding?
Yes.
Okay. All right. So Mr. Fike, first, let's deal with your contempt motion because that is based on the parenting plan that's currently in effect. So I do have your, I believe, July 27th motion. What would you like me to know about your request for a contempt finding?
Well, to start with, so in our parenting plan, we are to communicate with the well-being of our daughter, Liliana. Since about March of 2022, I have been blocked by Miss Manley. She has made it clear. I have attached text messages saying that I'm blocked. I think she actually filed some as well. She uses my dad as a third party, which over the course of that length of time, he has asked several times for her to stop communicating with him because she has done nothing but harassed him and caused him health issues. And I would like that to stop. I would like her to be held in contempt for having me blocked. That goes against our parenting plan. The second one is my daughter, or our daughter, Liliana, constantly comes to our house, tells my wife, myself, and my father that she does not like us, that her mother hates my wife, that she has told my wife that my mommy says that you are a bad person. And I would like for this to stop. She uses the word hate. She's 3 years old. She should not know the word hate. The third one, the biggest one, was also to change the parenting, was poor hygiene.
That's the basis for your adequate cause motion, not your contempt motion, right? Your contempt is based on comments from the child about you and your, I guess, spouse now or partner, and the blocking of you to communicate directly about kiddo. Is that right?
Correct.
Okay, let's deal with that first, and then we'll get to the adequate cause, because I did see the dental information supplied in there. So Mr. Fike, help me out. I have gone back and looked at your July 2nd, 2021 parenting plan final order. I'm not seeing anything in there specifically, but perhaps I just missed it, that states that she has to communicate directly to you about the child, or that she can't use a third party. I'm just stating that I'm seeing under other orders, what was typed in, which is pretty common in parenting plans, is that the child has to be able to freely communicate with the other parent. Each parent has the right and responsibility to ensure the child attends to school, etc., can schedule extracurricular activities. I do see a comment about neither parent will make or allow others to make negative comments about the other parent. Neither parent shall ask the child to make decisions or requests involving the parenting plan. You're not supposed to discuss the parenting plan with the kid. And then if there's an intent to remarry or establish a new live-in relationship, you can't expose the kid to those until the relationship's been going on for 6 months or more, et cetera. I'm not seeing, and again, please point me to it if I'm missing it. I'm not seeing anything that precludes her using your dad or any other third party to communicate with you if she wants to not have direct communication. So help me out.
It's just my understanding that, you know, we were to have direct communication for Liliana. When we have issues, when she comes to my house, I have no way of contacting her.
Yeah.
Like, my dad has sent her messages and she makes threatening messages or derogatory comments towards him. You know, he's 65 years old and does not want to deal with this stuff. He's not a part of it.
Yeah. So what I'm going to do on your first reason for contempt is deny it. I don't even need Ms. Manley to respond to it because it's not in your parenting plan. Here's the thing. I understand your frustration. So on just a personal level, I can absolutely understand how it is difficult to communicate when one parent won't communicate with you directly. But a contempt motion is asking me to find that there's been a direct violation of a final order of this court. And I can't find that just based on my review of the 2021 parenting plan. Ms. Manley's behavior, although unhelpful, is not contempt. So let's move on to the second reason you have filed for contempt, which is the negative comments. Ms. Manley, what can you tell me about that? And let me start with just reading what the 2021 parenting plan says. It says neither parent will make or allow others to make negative comments about the other parent or the other parent's past or present relationships, family, or friends within hearing distance of the child, nor shall they allow the child to make disparaging remarks about the other parent. So you've heard Mr. Fike's statement about things child may be saying when they are with him. What would you like me to know?
I would like you to know that I have not made comments about Mr. Fike or his wife to Liliana because she is 3 years old and she loves them. It would hurt her feelings if I said anything like that. And I'm not going to go out of my way to hurt my 3-year-old daughter's feelings on purpose. I filed a screenshot from January 20th of this year where I was telling Mr. Fike that she was saying the same thing to me. Daddy doesn't like you, you know, Titi doesn't like you. And I sent Mr. Fike a message saying that I'm not okay with that. And if it continues, I will file contempt of court on him because I do not take that thing lightly. So what Mr. Fike has done is simply turn it around on me. I have at no point in time spoken badly about him or his wife to our daughter.
I have reviewed the documents that were filed as part of this request, and I'm going to deny the motion for contempt in total. Number one, I've already stated my reasons for denying it on the first issue. I just don't, I think I can't find more likely than not that Ms. Manley is the reason that these comments are being made by a 3-year-old. And I'll be honest as well, the court typically, so out of court statements made by a 3-year-old are typically excluded from the court's reliance on the truth of the matter asserted under a child hearsay rule. So absent some other evidence that directly would link Ms. Manley to derogatory statements about Mr. Fike or his new partner, I can't find that there's a direct violation, a direct and knowing violation of the parenting plan. So I am going to deny Mr. Fike your contempt motion. What I'd like to do at this point, though, is move on to your request that this court find adequate cause to change the parenting plan. And the court obviously takes into account statements you've already made for purposes of the contempt hearing, but it sounds like you do also have some additional evidence you would like the court to consider.
In addition to.
Go ahead. So it sounded like you wanted to talk to the court about some of the medical concerns you have with regard to your request that I find adequate cause to set this on for a trial to permanently change your parenting plan from 2021.
Yeah, so the poor hygiene So on August 30th of this year, in about 2 weeks, our daughter Liliana is going to go to the dentist to have 6 cavities filled, 1 for sure root canal, and possibly 2 root canals. And this is due to bad hygiene from the doctor, the dentist telling us so. I filed the findings with the court from the dentist. They are also in compliance. They said that any additional information that the court needs, they will provide that for you. The rashes and the bug bites are constant. Every time Liliana comes to my house, she has a rash in her downstairs area. Now, when she's here on Fridays, we're able to put rash cream on it. By Sunday, it's completely gone. Wednesday nights, we put rash cream on it. We've communicated through my father. Any other communication can't happen of her having to, take care of our daughter and the hygiene, and she does not comply. It is constant. So recently I had a vacation week with my daughter. There was a doctor's appointment that we were going to take her to on August 1st. Upon arrival, that doctor's visit was canceled by Miss Manley. The Kaiser Permanente was very confused as to why it was canceled, because according to their records, my daughter has not seen a doctor in over 1.5 years. The Child and Adolescent Clinic has kicked her out of their facility due to canceling appointments, not showing up to appointments. And I'm waiting for documentation on that. They said they have 14 days. It's been about a week or so now, so it should be any time I should be receiving those. I just got her in for her 3-year well child exam. Next month she goes in for a 4. I think all this shows that Miss Manley is not caring for our daughter on a regular basis. She has called CPS on us, saying that we have infestation of bug bites, when we have pictures that I have filed with the courts, and CPS has seen that those bug bites are not coming from our house. There are text messages from Miss Manley saying that they are coming from her house and that she has taken care of the problem, which obviously hasn't, because it continues. I have a picture of methamphetamines that Miss Manley is holding in her hand. That was a text message from her neighbor's ex-boyfriend that apparently her son had picked up and given to his mother. The neighbors constantly complain about the way Miss Manley is treating my daughter and her older brother. There are statements that have been filed with the courts. Miss Manley says that they're 1 year old, which I don't understand, since the dates are clear on there, and numbers that we could call either one of those witnesses, which are directly next door to Miss Manley. CPS is involved with this case. They are going to be filing or coming back with collateral very soon. We're waiting on that.
And what do you mean collateral?
I was a little confused by that. I think it's a statement on what they found.
So meaning, and that's not something you have filed with the court. So are you saying that there's an open investigation by CPS into Ms. Manley?
Yes.
Okay. And you believe something further is going to come of it?
Yes. In fact, my text message from her says that she will follow up with collaterals. She's advised me to come here to court today with my pleadings and findings, and that she will follow up with collaterals.
Okay. Let me hear from Ms. Manley. Ms. Manley, what can you tell me about any knowledge you have of a CPS investigation?
This is about the 3rd or 4th CPS investigation that I've had on me. The previous 3 were found false, and they were closed down immediately. Mr. Fike has called them on numerous occasions with nothing but blatant lies. At one point, he called them and told them I was burning her fingers to punish her. I had a sheriff officer show up here with CPS lady. They came into my home. They checked out Liliana for bug bites, bruises, burn marks, etc. They found nothing, and the case was closed the same day. That was in February. I've had another time he called CPS on me and told them I was doing meth. I took a drug test. I passed it. That case was also shut down. It's been ongoing calls to CPS from Mr. Fike, and they've all been unfounded. CPS showed up at my house last Friday again. And she told me that Mr. Fike was accusing me of doing drugs again. I submitted a drug test on the spot. The results should be back in 1 to 2 weeks. They will also be negative. I live in a transitional housing program run by the community house on Broadway. I've lived here for 4 years now. Mr. Fike lived here with me last year. So he's well aware of the fact that we do weekly drug tests here. We have mandatory reporters that show up to do house visits at random. They constantly keep check of the children's welfare, the state of the home, all that. I have never had a warning, nothing.
Here's what I'm going to let the folks know too. And I have reviewed the declarations, Ms. Manley, that you filed in response to some of these allegations. I went back and looked at the 2021 Guardian ad litem report. Mr. Fike, I'll be perfectly upfront with you. Several of the allegations that you're lodging now against Ms. Manley, you also lodged in 2021. And the Guardian ad litem at that time stated that the allegations against the mother and her mental health are unfounded. And according to the investigation by the GAL, the natural mother takes good care of the child. As a result, and I've read the entire GAL report, when the GAL looked into this matter, essentially found that neither one of you would be deemed inadequate parents, hence the parenting plan that was put into place. The history I see in this case since that time is just serial contempt filings and continued allegations about the same behavior that was already investigated and deemed not credible. The only thing that kind of raises my eyebrows and probably keeps me from making a ruling today is an open CPS investigation and a drug test. So what I'm going to do, because we already have you folks on next week for August 23rd at 9 a.m. for Ms. Manley's motion, I would like to, I'm going to reserve ruling on the adequate cause request by Mr. Fike. So Mr. Fike, that means I'm not granting or denying your motion today. I'm asking for more information. I don't know if we'll have that information by next week at 9 a.m. But what I would like is if Ms. Manley, if the drug test you just took does come back, please file that with the clerk of this court. I would like to see those results. And then Mr. Fike, if you do get additional documentation from CPS, please file that with this court. I would like to know, if CPS finds this latest allegation unfounded, I want that. If they believe that there's further follow-up or whatever this collateral is, I want that. So I'm simply reserving ruling for additional information. Do the parties have any questions for me?
Yes, ma'am.
Go ahead.
I'm a little confused. You say you went back to 2021. All of this that I've filed recently in this case are things that have been brought to my attention. Okay, the blocking.
Mr. Fike, hold on. Let me be very clear. In reading the GAL's report from 2021, I understand you're alleging new dental issues. I am taking that into account. I'll also tell you, 3-year-olds with dental issues, very common, see it all the time, and it does not necessarily mean that any sort of neglect or abuse has occurred. I need something more than that if I'm going to find adequate cause to change a parenting plan. What I'm telling you is, in reviewing the report from 2021, you at that time were alleging drug use, you were alleging rashes on kiddo, you were at that time alleging other medical conditions, including constipation, you were requesting mental health evaluations of Ms. Manley. All of those things were deemed unfounded when investigated in 2021. So while you may be bringing up some additional new factors, I'm telling you, a lot of this appears to be a rehashing of things the court has already ruled on. So what other question do you have for the court? And I hope I've been clear about what I want from you, which is any follow-up from CPS into this latest call-in that you've made on Ms. Manley. And I want the drug test results before I make a ruling.
Right. So everything that you brought up as far as the 2021, all those allegations were from Miss Manley to myself. I had to go take a hair follicle test. My
I
wife had,
understand. That's not true, sir. Actually, in the report, the GAL had concerns about your allegations against Ms. Manley and specifically stated the allegations against the mother and her mental health are unfounded. And according to the investigation, the natural mother takes good care of the child. I'll also tell you that the gal found that the child was well cared for with both of you. Okay, so this is not one-sided. The reason your parenting plan was adopted the way it was is that the GAL found both of you were doing a good job. Okay, so I've told you what I want to see next week. If we don't have it next week, we can talk about what date we expect to get that evidence. But standing here right now, I do not believe there's enough evidence for me to rule on your request for an adequate cause motion. So we are going to set it over to next Wednesday, September 23rd, when you folks are already scheduled to be here. Are there any other questions for me?
is it possible to make it to where I can get Liliana into a doctor and make sure she gets to her dentist appointment? Kaiser won't even see or talk to or communicate with her mother because she constantly, she constantly, I'm sorry, I'm having a hard time with this one.
Okay. Ms. Manley, is there a reason that you can't assist in getting child to the doctor and dentist in short order?
I have no problem getting her to the doctor or the dentist, and I have no problems with Kaiser whatsoever. I've never missed an appointment there, and I'm the one who set up the Kaiser visits to begin with.
Okay. When is the next, when's the next doctor? Either one of you can answer this. When's the next doctor or dentist visit scheduled for child, or do you have a date scheduled?
Her next doctor's appointment is September 1st. However,
is that at Kaiser?
Yes, Liliana has only been seen once at Kaiser, and that was when I took her. The only other appointment she's had was over a year and a half ago with the child and adolescent clinic. Again, they had booted her because of canceled appointments. I have that documentation coming. I will be filing that.
Please do. If so, child has an appointment with the doctor on September 1st. Whoever child is with on September 1st, I expect that appointment to happen. I don't want to see a canceled appointment on September 1st. Is that clear, Ms. Manley?
Yes, ma'am.
Okay. And then do we have a dentist appointment scheduled?
Yes, she has oral surgery on August 30th.
Okay.
And I have been requested by the dentist to be there with her.
Okay. And where is that taking place?
Harbor Kids Dental right here in Longview.
Okay. So Ms. Manley, on that date, even if that is a scheduled date where you have child, I am going to approve Mr. Fike to be the responsible parent for taking her to that surgery.
That's okay.
Okay, is that understood?
Yes.
Mr. Fike, is that is your request and it works for you, correct?
Yes, ma'am.
Okay. Okay, anything else folks need from me before next Wednesday when I see you back here at 9 a.m.?
No.
How much can be filed?
Sorry, say that again.
Like how much more can I file to prove that she's in contempt? And
well, the contempt motion I've denied based on the 2 reasons that you filed your prior contempt motion. So if there are new reasons for contempt, you would need to file a new motion and you can submit whatever evidence you want for those new findings of contempt. What you can supplement now, because I'm reserving ruling on, is your request that I find there's adequate cause to change the parenting plan. So that is what the court would accept additional filings on right now without you having to file a new motion.
okay.
Does that make sense?
Yep.
Okay. Ms. Manley, any questions for the court?
No, Your Honor.
Okay. Thank you both. We'll see you next week in our digital file.
Thank you.
And Ms. Westling, can you hear the court?
She might not know how to unmute.
Oh.
Hello?
Hello, Ms. Westling, can you hear the court?
Yes.
Okay. So, going back and looking at this case, and you two have not been in front of me before, but I have gone through the history of your case. when you were last in front of a judicial officer back on June 14th of this year, it appeared that there was an issue of potential contempt. And what the court ordered at that time was, at today's hearing, we might need to take additional steps if $70,000 had not been paid, as that was due and owing to Ms. Westling. There was some discussion about sale of a home. So let me start with you, Ms. Westling, and tell me where you're at with receipt of any of the money.
Okay, hold on a sec.
I think we have to push it every time.
There you go.
Sorry.
We can hear you.
Okay. He tried for a $70,000 loan and they wouldn't give it to him.
Okay.
Even when you're going down and taking my name off the title of the house, which I resented, but that's beside the point. And there was two other ones that were supposed to have been taken care of too. There was one for LPL and a 401k. And as of yet, I haven't received anything.
Mr. Westling, tell me what's going on. I'll just be really clear based on my review. You were given 60 days back in June to make a $70,000 payment. Where are we at?
Loan was, it was, went to almost termination for the $70,000 for Nancy. And, the lenders, the loan was disqualified because there was a deed of trust for $84,000, and the lenders wouldn't allow the loan. So what I did was, there's a new loan started right now for the full. The $70,000 was for her part of the house, and what I did was I started a new loan for the full amount of her part of the loan. She was supposed to get $70,000, and then $84,000 was going to be for a deed of trust that the title company put on.
So I'm hearing, just let me kind of speed this up. So what I'm hearing is no payment has been made.
Right.
Okay. You're working on getting that money. What's the time frame that you're working with now?
I'm requesting the court to give me a 60-day extension, so that the full amount of $154,000 can be paid to Nancy, and that her half of the retirement fund will be transferred into her name. They don't want to transfer the money into her name, so that it shows that I have enough earnings to qualify for the loan. So they kind of go hand in hand.
Okay, so help me understand just a little bit. If you got denied for the $70,000, how are you expecting to get approved for $150,000?
Well, it was denied because of the deed of trust that was put on the loan from the title company, and the bank doesn't like to play second fiddle to that deed of trust.
Okay.
So what we're doing now is, and I'm working with my financial guy from LPL Financial, Craig Beard, and Kathy Weaver with Mason McDuffie Mortgage Corporation. She's pretty confident that I will be able to get the $154,000 loan, which would be that $70,000 and the $84,000, and there won't be any deed of trust.
Ms. Westling, what is your position on this request for more time to get the full amount to you?
Well, that's him refinancing the house is what he's doing.
I can't understand you. Can you repeat yourself?
He's trying to refinance the house to get the $150,000. And the LPL, he can't do that until he gets the house redone, because he wouldn't be making enough money. If he comes up with $150,000 before the next one, then we'll discuss the other. I mean, it's one of those. There's three of them that he's supposed to give me money.
Yep.
Supposed to be 150, and then there was 150 out of Portland, which they want to buy me out, which I have to give them 20% of it to get it. And then there's the one that Craig Beard has that he wrote in there that I could have, and that's close to 40. So that's where I'm at on all of it. And as of yet, all I'm still getting is the Social Security check for $1,200 a month, which there's no way humanly possible that I could get a place of my own that way.
So here's what I'm going to do. I am looking at the CR 2A agreement that you filed with the court as part of your January dissolution.
Yes.
And the $152,500 was agreed to be paid within 30 days of January 6, 2023. That hasn't happened.
No.
Then the share of the equity of 100 Winchester Drive was listed as $154,555. Within 60 days, again, of January 6th, Mr. Westling, you were supposed to obtain, the word is shall, which means you have to. It's not no waffling there. Shall obtain a loan in the amount of $70,000 to pay Ms. Westling. Again, that was in 60 days.
But ma'am.
Hold on a second.
Okay.
Then there were additional qualifications for things that were supposed to be paid. But what I'm primarily looking at first is the $70,000 that the court addressed last time and gave you an additional 60 days to pay, even though here we are 8 months. So we're 8 months past the decree of dissolution. We're 6 months past the date the original $70,000 was supposed to be paid, and the court already gave you an extension of 60 days. So what I'm going to do today is I'm going to give you 30 days. I'm going to give you 30 days from today's date to make the initial $70,000 payment at least. That's the bare minimum that needs to happen within 30 days. If we come back in 30 days and that payment hasn't been made, or I don't have documents from a financial institution telling me that money is coming in short order, Mr. Westling, you are not going to like the other tools that this court has to enforce contempt. And I don't want to go there. I really, really don't. I don't think it serves Ms. Westling because she can't get her money. And Mr. Westling, certainly you don't want the court to utilize those other tools. So please, 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 I'm going to give you 30 days. We're going to set this out to September. Let's just give you a little more than 30 days because I know how financial institutions work. Let's go to September 20th, which is Wednesday at 9 a.m. By that date, I want to see that $70,000 at least has been paid, and then we'll talk about all the other stuff. But I want that amount to be paid, or documents that it's coming in short order from a financial institution. If we don't have that and we don't have assurance of payment in short order, I am very likely going to enter an order with a very strong finding of contempt with sanctions. And I don't think that serves either one of you. Okay. So Ms. Westling will be back on September 20 at 9 a.m. If before that time payment is made, you certainly, Ms. Westling, can let the court know and we can strike that hearing date. That is my ultimate hope for both of you. Any questions for me?
No, I just wonder what's going to happen with the rest of it. That's all.
Yeah, we'll address that on the 20th if it hasn't been paid.
Okay.
Mr. Westling, any questions for me? Any questions for me, sir?
No.
No.
I don't have any questions.
Okay. All right. We'll see you back on the 20th. I think you've got your work cut out for you, sir. So you're going to need a good luck.
Right.
There you go.
Thank
Okay.
you.
You're welcome. Can you try talking to the court?
Yeah, can you hear me?
Yes, I can.
Hi.
Okay. So, going back and looking at where we have come from and where we are, you folks know that you were in front of me on July 19th. Mr. Taft, we had no evidence showing compliance with payments. We did indicate at that time that further non-payment would likely result in a finding of contempt and jail time. What I have in my file is a new motion in order to show cause for contempt. This one now from Ms. Taft. Oh, my computer just clicked out of it. Let me get the dates. Now shows continuing non-payment through July and August. And it still does not, as best I can tell, this is all in handwriting. As best I can tell, has not made any payments on the prior contempt orders. So let me first start with the moving party, Ms. Teft. What can you tell me about any payments that have been made, looks like since May 5th?
Michael hasn't made no payments whatsoever. He's been told by judges numerous times, even by you, to make payments, and he still doesn't do it. He feels like he's above the law and that he doesn't have to follow court orders. And I just feel like he needs to go to jail to know that this is serious, because there's, at this point, we're at what, $5,000 already racked up from all the way from May to now, and he hasn't made not one payment. And yet he used this excuse of saying, oh, I don't work, I have no income, BS crap. But then he sits there and is going to the casino and buying other stuff. And I even have submitted his income one time. It should be in the file too as well. And his receipts when he was spending money like crazy and when he was working at CAP. And he could have made payments, but yet he's made not one payment.
Okay. Mr. Teft, can you go ahead and unmute and tell me where you're at in making payments related to the prior contempt orders in this case? And there you go. You're So Mr. Teft, you have horrible connectivity. We are getting about every third letter that you're stating. So I can't even make out a full word.
So I submitted a declaration.
You submitted a declaration from DSHS.
Yes.
It states that you've completed an appointment with a doctor. What else? What are you submitting that for?
Well, it states in the paper, it's regarding disability. So I think in all fairness, it's showing that I'm taking initiative to resolve the issue, but also, you know, just where I'm at financially too, you know, and what's being considered. So I think in fairness, to give it a little more time would definitely help the situation be resolved.
What kind of disability have you applied for?
Well,
you mean like, are you applying for financial? Say that again.
It's called ABD.
No, I'm asking, have you applied for like Social Security disability? Is that what you're applying for?
Yeah. Yes.
Okay. So that can take years to get. Years.
Your Honor.
Well,
Ms. Teft. Go ahead, Mr. Teft. Ms. Teft was cutting you off. Go ahead and finish your thought.
Yeah, so I know that Alonso was aware of that from our last hearing. I know she brought it up that, you know, she knew that I was applying for that. So, I mean, it's not like I haven't been doing anything, but also too, I'm just waiting on an answer from them. They told me it was going to take about a month for a response, whether I get it or not. So if that's the case, then I can do updates with you guys, you know, because I think in all fairness, it should be considered.
Are you working right now?
Currently, no, I'm homeless.
Okay. When did you last work?
I think that was the beginning of June.
Okay. How much money were you making in June when you last worked?
Minimum wage.
Were you working full time?
Yes.
And why did that job come to an end?
I was held in contempt and had to go to jail based on failure to pay spousal support. So I lost my job.
Are you actively seeking work at this time?
Currently, I'm waiting for a response first with the DSHS before I can do anything, because I think, you know, that it's a serious program and that, you know, I'm considering right now. So that's where my focus has been, is getting a response from them, doing what they require from me, and then going from there.
All right, Ms. Teft, you wanted to say something? Go ahead.
Yes, I feel like Michael's using this excuse to not pay stuff. Like when he was working, he could have paid at least some of it when he was working full time. I'm taking care of his daughter that he doesn't even take care of. I've got custody of her, and he's been making all this money and before, and now all of a sudden he wants to not work and he wants to file for a disability because he doesn't want to work all of a sudden. But it's like, even when you were working, you didn't make no payments whatsoever. So it's like, how you're going to sit here and say, oh, I'm not working, I'm homeless now, but yet I could see that as a fact if he was making payments when he was working. You know, he had all this time to make a payment when he was working full time and getting those hours, but he wasn't making no payments at all. Considering the fact I'm taking care of his daughter too, he could have made payments. I'm struggling trying to take care of her.
Yeah. So, Mr. Teft, I understand that you're stating you haven't worked since June, but what about the May and early June payments? Why weren't those made?
May and prior to well, yeah, courtly matters. You know, this isn't the only courtly matter. I'm dealing also with a custody issue and all that stuff. So, you know, with homelessness and the custody matters, and looking forward to these contempt orders. You know, that she was making threats prior to all this. It affected a lot of things, you know, financially. So, you know, that's kind of where I'm at.
Okay. So what I'm showing and what we're going to do, you have, Ms. Teft, you have filed a new contempt motion, I think, for the August payments.
Yes, I did.
Which is on August 30th. So I'm gonna, I need you to file an proposed order on that. You have filed those in the past, but I want to be clear about what you need to put in that order. So what you've been doing previously on the contempt motions and orders is you've been putting in every month, May, June, July, and now August. But each contempt order needs to be standalone for the new period. So I've had to go back and cross out the months that this court has already issued contempt on.
Oh, I did not know that.
Okay. Yeah. So what I'm going to do on August 30th, when we come back in 2 weeks, make sure you have supplied to this court your contempt hearing order. And in that, because I have already ruled on contempt in May, June, and July, the new order, I just want you to address August.
Okay.
So just put the August 5th payment for $650. Okay. And then Mr. Teft, what I'm going to say is you're going to be back here in 2 weeks. If you get approved for disability before then, please file at least a letter with the court ASAP. Otherwise, I'm going to be very clear here. If there's no payments and no letter stating you're going to be getting money in soon, I will be ordering you to report to jail on August 30th. Okay?
Yeah.
Okay. So Ms. Teft, when you provide that order for our August 30th hearing, put in the dollar amount. You leave blank the part about jail. I will make that decision, but I want you to fill out the August 5th non-payment. Again, and we're going to address that on August 30th. There will be a jail sanction if I don't either have proof that payment is coming shortly or that payment has been made.
Okay.
Okay. Any questions from me from either one of you?
My question is, for the past due, all the other past due that he never paid, does he still have to pay that, or
Yep.
is that?
Nope, those are all signed final orders. So the May and June contempt that I think was signed by a prior judicial officer still stands. The July contempt that I signed still stands. And now we're going to be dealing with an August 5th contempt. So when I say payment, I mean, I need payment on all of the support. I'm not talking about just making $100 and saying a payment was made. I'm stating I need Mr. Tuff to see some substantial compliance with getting caught up and staying current. The other thing I will accept is if there is a determination of qualifying for disability and we know money is coming in soon, I will take that into account. Okay.
Basically, he has to get a letter saying he got approved, right? That's gonna take that into account.
Yeah, if he gets something stating money's coming in soon, I will take that into account in whatever my ruling is going to be on the 30th. But I just want to be very clear with Mr. Teft that if neither of those things happen, if we're back in the same situation we've been in June and July where there's just no payment and there's no real indication that anything is likely to be paid at any time in the near future, then we will be ordering a jail sanction. That's kind of the last tool we have in our toolbox.
Okay.
Okay. All right. Thank you both. We'll see you back on August 30th at 9 a.m.
Thank you.
Thank you. And then Ms. Looney, is this the case that you're here on today?
No, Your Honor, I'm just observing.
Oh, perfect. Okay. So what I have in front of me is from Mr. Farmer. And this was when we were last here on July 19. We discussed child support and state benefits. We approved temporary orders and we set this matter to August 16th at 9 a.m. today to review. I think you all completed mediation on July 13 and came up with your primary residential placement and schedule. I have since received since we were last here, the financial declaration from Ms. Hanson. And so let me just be clear, is child receiving any sort of state assistance?
Yes. Right now I have SNAP benefits and just health insurance for them.
Okay. Hey, Ms. Looney, since I do have you here, I might pose a question to you.
Yes, Your Honor.
If you don't mind, in a case like this, where we're being presented with child support orders following a mediation that set residential schedule, but there is interplay with state benefits, is this something that would need to be served on your office first for input?
I am checking to see if there is anything that we would need to look into, Your Honor.
Okay.
To see if there is an open case in our system.
Perfect. So while she's looking at that, Ms. Hanson, have you had a chance to review Mr. Farmer's proposed child support worksheets?
No, I have not.
Oh, you haven't? Okay. So Mr. Farmer, it looks like you maybe submitted these around August 10th. Does that sound right?
That's when I started working on them. So basically what happened was I did what you told me to do, go in and turn in the parenting plan to the prosecuting attorneys. And then they told me to go to the clerk's office. And then I go there and then they told me how to fill out these worksheets. And I have no idea how to fill them out. So I was just trying my best. And yeah, I got it done and then submitted it.
Yeah, understood. I think at the very least, Ms. Hanson would need to have a chance to review these before the court could take any action.
Okay, then I'm gonna have to get copies and give her them.
Yeah, but I'll also just wait for Ms. Looney to see if there's something open in their office.
I am back, Your Honor. I did check. We do not have an open case in our system, so we would not need to be involved in setting the support for this child.
You would not need to be involved. Okay.
No.
Okay, great. So what I'm going to do then, folks, and as you've probably heard me say to other folks, I understand working through these worksheets and cases without attorneys can be complicated. I'm not stating anyone has done anything wrong here, but Ms. Hanson does have the right to review the proposed child support worksheet and the temporary order before I would take action on it. So are the two of you at a point in working together where you would be able to email each other these documents?
Yeah, we could.
So my hope would be just a real short set over of this case. I would hold on to the proposed orders. And then Mr. Farmer, I'd have you email them or give them, however you two prefer, to Ms. Hanson to review. Ms. Hanson, you did submit, I believe, a financial declaration.
Yes.
So that's good. I have that to review. But take a look at these worksheets and orders. And if you disagree with them, file any disagreements with the court before our next hearing. And then we can have a hearing on, I'll look at the proposed order and I'll look at any objections you have, and then I'll make decisions on what the final order should look like.
Okay.
Does that, okay, go ahead, Mr. Farmer. You might have a question.
Yeah. Okay. So, on our last hearing, you told me that I had to fill them out because you're not sure if the state has to be involved or not.
Right.
That was the only reason why I submitted those documents, because you told me to.
I did tell you to, yes. And you did the right thing. You did. It sounds like you did drop them off with the prosecutor's office, and they don't have an open case in their office. So you've done the notice that you're supposed to do, and there's nothing more that you need to do with their office.
Okay. Also, there was another thing.
Okay.
So when we completed a mediation, I was going through the parenting plan, and they did do a typo on it where we would pick them up. It says 3:30, but it's typically 3 o'clock, and I told them I get off at 3:30, so they ended up putting 3:30 down. I contacted them about it, and they said that all I had to do was just cross off that time, write the correct time, and then both of us initial it, which we did. And then I went into the clerk's office yesterday about it, and they said I have to resubmit a whole new parenting plan, basically the same, just change the pickup time.
Yeah, and I'm just looking to see, are you talking about the weekday pickup where it says Tuesday at 6 to Friday at 3:30?
Yeah, Friday at 3:30. We usually pick them up at 3 o'clock, and that's where they messed up, and they typed down 3:30.
3:30, okay. Do you have a copy of the proposed? Do you have a copy of what they did where you could just make that correction and resubmit it?
Well, the clerk's office told me that I have to get a whole new form and redo it, and then write on it amended.
Well, what I'm just wondering is, instead of, we can write in the word amended, but what I'm wondering is, do you still have a copy of the unsigned order, or do you only have the order that I've signed?
I can look. I might still have the unsigned one.
Yeah, because if you just have a draft of what you originally submitted to the court before I signed it, because we can't just redo the one I've already signed.
Yeah.
But if you don't have to start from scratch if you have the original order that you submitted before I signed it. So it doesn't have my date or signature on it.
Okay.
Then you could just cross out 3:30, write in 3 o'clock, resubmit it to me. And when we come back to talk about child support, I'll just have you both go on the record stating you agree with that change, and I'll initial it and I'll sign it, and we'll call it the amended parenting plan temporary.
Okay.
Does that make sense?
Yeah.
Okay. So how much time do you think you each want, Mr. Farmer, for you to get the proposals to Ms. Hanson, and Ms. Hanson for you to have a chance to look at them and file any changes or objections?
You're talking about the worksheets, correct?
The worksheets, yep.
I can get those as soon as I get off work today.
Do you guys want to do a 1 week set over? Do you want 2 weeks? What's your preference?
I'm open for next week.
Ms. Hanson, do you think that next week is okay?
Yep, that works for me.
Okay, let's just set you over 1 week to August 23rd. I'll keep the proposals you already sent, Mr. Farmer, and then the only other thing I'd be looking for is the amended parenting plan. If you just resubmit me a clean copy that I can amend on the record next week, we can get that done for you.
Okay, and I just need to cross out the time and put the correct time, and that's it.
Yeah, just put in 3 o'clock instead, and then I'll go ahead and just, again, ask for you guys to agree to that on the record. I'll initial it, I'll sign it.
Okay, perfect. Thank you.